Hello, everyone, and welcome to our webinar on navigating risks in GP mergers and takeovers. My name is Sophia Palmer, and I'm an Associate Director and Solicitor at BMA Law. So just to give you a bit of background about us, we're an independent law firm established by the BMA. We offer expert, cost-effective legal advice, and unlike other law firms, we offer a BMA member discount, and we aim to reinvest any surpluses back into services for doctors. So just to let you know, this webinar is recorded. The webinar will be split into two sections. There'll be a talk given by me on navigating risks in GP mergers and takeovers, and then a Q&A. If you have any questions, please type these into the chat box and I will try to answer these to the best of my ability. If there are questions that I am unable to answer or do not have time to answer, we can follow these up with you after the webinar. So please do feel free to contact me. My details will be on the final slide and you'll have time to take these down. So firstly, we'll look at the key steps in a GP merger or takeover from a legal perspective. We'll then move on to look at the risks and how to avoid these. And then we'll look at the key documentation required in a GP merger or takeover. When dealing with a GP merger or takeover, the premises is an important asset or liability, and this webinar will briefly touch on the premises aspects. However, property law is not my area of expertise. I'm a commercial and corporate solicitor. So if you have any questions in relation to the premises aspects of a GP merger or takeover, please put these questions in the chat box and I will ask our property team to follow these up with you. So I'm quite often approached in relation to practices who are considering a GP merger or takeover, and they're looking for guidance on what to do at the outset to ensure that a merger or takeover goes through as smoothly as possible. So in simple terms, you are merging or undergoing a practice takeover where one or more practices join together to form a single practice. There are various ways in which this can be done, and I would recommend engaging with the ICB in the early stages to discuss how your GMS contract or PMS agreement will be merged. So, for example, one contract will be absorbed by the other. There could be a situation where the contracts could be merged and a new contract is formed, or you can retain and run two separate contracts. And when considering the options, I'd be mindful of procurement regulations and I'd seek advice at this early stage. At the outset, the key questions that you'll be asking each other are whether the merger or takeover is right for you. And there are several advantages of forming a larger entity. For example, it has the potential to reduce workload pressures. It can give you the ability to offer increased or extended patient access and the ability to bulk buy or reduce costs. Sometimes you have the option of sharing space and administrative workloads and staff. There are sometimes disadvantages to merging or taking over a practice, and these can arise where the respective practices have liabilities, for example, historic service charges. These can pose issues if positive action to mitigate those liabilities or ring-fence them isn't taken. So in addition, partners may have less influence on decisions, especially in a larger practice, and sometimes each practice will sacrifice an element of their independence. So to avoid these issues arising, especially with regards to liabilities, I'd recommend including robust indemnities to deal with any liabilities, and then drawing up a comprehensive partnership agreement, which deals with decision-making and governance procedures. So you'd want a governance structure that sets out how the merged partnership will run following the merger or the takeover. And we'll go into these legal agreements in more details and the provisions that you need to include to deal with this. So the key steps. The process that you'll follow will largely depend on the amount of time that you've got to plan and prepare for the merger or takeover. We'd recommend starting the process at least 12 months in advance. This should give you ample time to get everything, including your legal documentation, in order. At the outset, we recommend preparing heads of terms or a memorandum of understanding. This is a useful legal document that sets out the intentions of the partners, but is not legally binding. The heads of terms usually set out the basics, for example, the intended completion date, the intentions that each party has with regards to the property, any agreements reached with regards to assets and liabilities of the practices, and what the partners intend to do following the merger or takeover. For example, are they staying on as partners or are they exiting? If so, if they're staying on what terms, so what their sessions, profits, holidays, and if they're retiring, on what terms will they be exiting and when will they be paid out. At more or less the same time, you want to be carrying out legal and financial due diligence. The purpose of carrying out legal due diligence is to elicit information about the practice that you're intending to merge with or take over. For example, you'll want to find out details about employee grievances, negligence claims, and patient complaints. We also recommend carrying out financial due diligence, and your accountant can usually help with this. Financial due diligence is incredibly important, especially in the early stages. We also recommend approaching the ICB at the outset, and we've already discussed your GMS and your PMS, GMS contract and your PMS agreement and how they can be merged. We'd also recommend understanding the CQC requirements at an early stage, so ensuring that you've got any relevant applications prepared. So, for example, adding a new location or a new registered manager. You then need to start thinking about formalizing these terms in a legal document, and that's what we call a business transfer agreement. The business transfer agreement will help extract any relevant points that need to be agreed. So, for example, will there be a purchase price? Will you be purchasing any equipment or assets? Is there any stock that has any value? And if so, how will this be valued and when will the payment be made? Are there any vaccines that need purchasing as well? It should set out the mechanics of the merger or takeover and include indemnities in relation to existing liabilities, if that's what's agreed, and any relevant warranties. So just to explain, indemnities are promises to reimburse on a pound-for-pound basis for a breach of an indemnity, and we usually see blanket indemnities in GP takeovers, mergers, but we'll go into those in more detail. Importantly, you'll want to think about how the property is dealt with. This will depend on whether your properties are freehold or leasehold. If they're freehold, the partners will be expected to buy in, or will they be expected to buy in? That's one of the questions you need to ask. If so, when and how? How will the valuation be carried out and on what basis? So all points to be agreed, and to be agreed in advance to avoid any dispute or dissatisfaction. If the properties are leasehold, you'll be considering whether the lease can be assigned or if a new lease should be put in place. I'd recommend that you discuss the property points with a property solicitor at the outset because that can sometimes take a bit of time. As mentioned above, you'll need to give careful consideration to how your employees are transferred across to the new practice. This will usually occur as a result of TUPE, so a TUPE transfer, and you'll need to seek advice on the transfer of the staff and any measures that you intend to take. So, for example, changes to employment terms. We recommend discussing these with an employment solicitor or even with the BMA EAS, as they may be able to provide some assistance. Finally, you need to think about how the practice will be run following the merger or the takeover. We'd recommend ensuring that you've got a robust partnership agreement in place for the practice ongoing after the merger or takeover. This should cover how the practice will be run, how decisions are made, profit shares, sessions, and buy-in provisions for any new partners, and then importantly, leave provisions. So if anyone's intending to leave after the merger or takeover. So I've gone on to highlight some of the key risks to be considered. It's important to note that this isn't an exhaustive list. It's a list of key risks that we tend to see and tend to consider, but each merger or takeover has its own set of facts and therefore will have its own unique risks. So due diligence. As the takeover or merger progresses, the lack of due diligence can sometimes be problematic, as unforeseen liabilities can crop up throughout the process or even after the merger or takeover has taken place. If we're able to identify liabilities prior to the merger or takeover, then we're able to include specific indemnities in relation to those liabilities, meaning that you'll be indemnified on a pound-for-pound basis for any liability that arises in relation, or any loss that arises in relation to that liability or breach of indemnities. If these liabilities are identified after the merger or takeover takes place, then you won't have the benefit of a specific indemnity. therefore those liabilities are going to pose an issue for you. So although due diligence doesn't have to be full on and to take up copious amounts of time, some due diligence, especially legal due diligence, is a must, even if you're carrying that out yourself. Due diligence can be very useful to uncover things such as losses, liabilities, claims, employment disputes, potential and ongoing litigation. So we would always recommend carrying out some form of legal due diligence. You don't necessarily need to instruct a solicitor to always do it for you. You can do it yourself, but we would say definitely do it. And ensure that you're also carrying out financial due diligence, because that tends to be quite important, especially in the early stages when you're considering whether a merger or takeover is right for you. Secondly, financial risks. You need to consider the financial risks associated with taking over or merging with a practice. For example, if there's a purchase price, have you looked into the quality of the assets, the equipment price, any stock, any unused vaccines? It's important that you consider what you'll be paying for those at the outset, because sometimes we approach completion or exchange, and it's only at that point that people are saying, well, actually, these vaccines cost us a lot of money. We need to be paid for them. So I would say consider the finances at an early stage, and also look for any losses, liabilities that you need to mitigate, or you need to ring fence, or you need some protection in relation to. If you are paying for anything in relation to the merger, so the property, equipment, assets, you need to be clear as to how these valuations are going to be sought, how you're going to reach the valuation ahead of the merger, and ensure that you achieve a fair sum. So all of this needs to be written into your agreement. Again, if there are any liabilities related to the practice prior to the merger or takeover, these risks need to be provided for prior to the completion date within the agreement. We recommend that you start talking about these issues early, and you've got a clear understanding of what you're going to be purchasing, and consider any specific indemnities that you need in relation to any potential or ongoing litigation or claims. So speak to your advisors early. Then the next type of risk that we tend to see is in relation to your workforce. So it's important to keep in mind your obligations towards your employees when merging and taking over a practice, and whether TUPE applies. If it does apply, you need to ensure that you're complying with your obligations under TUPE, and ensure that you avoid any potential claim for failure to comply with your obligations. You need to consider whether there'll be any staff resistance, and whether this could potentially derail the process, and how it's best to deal with this. So thinking about when to involve your staff in the process is important. Merging and taking over a practice can sometimes result in the exit of partners and staff. In relation to partners, we recommend that you have clear exit provisions within the BTA or your merger documentation to cover the terms of their exit. So you'll need to set out how they'll leave, when they'll leave, and how they will be paid out. Really important, especially if the composition of the partnership is changing throughout the takeover or the merger. Finally, regulatory requirements and compliance. We always recommend that you start liaising with the ICB at the outset, so you know when your contract variation notifications need to be submitted, and ensure that they're submitted in good time. If not, they can derail the process and cause delays. It could mean that you end up working in partnership for longer than anticipated, and that partnership is usually in place to facilitate the transfer of the contracts. So you need to ensure that you've got your notifications in at the right time, and you're prepared for any period of partnership that you have to be in partnership together. Finally, you need to ensure that you're aware of any CQC requirements, so any registrations or applications that need to be submitted. So we always say plan in advance. So I've set out some of the structures and various models that merging or taking over a practice can take. Model 1 is a loose arrangement. It's where the practices share back office and management staff. It's not really a merger or a takeover. It's more of a contractual joint venture, and we still recommend seeking legal and financial advice on this. Model 2 is where the GP partners from practice A join the partnership of practice B, and vice versa. The new partnership may continue to hold 2 contracts, but they will have merged at an operational level. Model 3 is where the GP partners from practice A join the partnership of practice B and practice A ceases trading. The ICB then terminates practice A's contract and varies practice B's contract to include the services originally provided by practice A. And model 4 is where the GP providers come together to create a new legal entity and a new contract is awarded. This may involve incorporation, so novation of a contract, the creation of a new partnership, or something similar. And what we would say in this circumstance, just be aware of any procurement legislation and ensure that you're aware if a contract needs to be put out for tender. So speak to your legal advisors at that point. So once you've decided on the model, discussed with the ICB, carried out the due diligence, agreed your heads of terms, the next step is to formalise the merger or takeover in a business transfer agreement. And the BTA sets out how the contracts will be merged. It deals with the transfer of the assets and the equipment. It should address how any existing liabilities of the respective practices should be dealt with. So any existing claims, any complaints, any employee grievances. It will also cover various indemnities and sometimes warranties. So a warranty is a factual statement given by a seller, and it often offers the buyer a form of contractual protection in relation to the assets and the business being purchased. So, for example, a promise that a practice has complied with all of its regulations and applicable laws. An indemnity, on the other hand, is usually for all losses suffered or incurred by a party for the period up to the completion date. So that's a blanket indemnity. An indemnity is a promise by a practice to reimburse you in respect of a particular type of liability or loss should it arise. And the purpose of the indemnity is to provide a remedy on a pound-for-pound basis for a breach. And finally, you need to consider whether there are any liabilities or assets that you want to exclude from the takeover or merger. So, for example, are there any assets that the partners own individually? So, for example, a painting hanging on a wall or a piece of furniture that you don't want to transfer. If so, you need to specifically exclude those so they belong to you individually. So, as already mentioned, you need to ensure that you have a robust partnership agreement in place from completion, as it will govern how the merged partnership or the new partnership will be run going forward. You may also need to document any retirement terms for exiting partners within the partnership agreement or in a transitional agreement. Sometimes you can do this in a separate document called a transitional agreement or short-term partnership agreement, and that's where all of the partners go into partnership for a short period of time in order to transfer your GMS contract. So not always needed, especially if the takeover happens overnight or in the space of 1 hour, 1 minute, or if it happens over a weekend when you're not actually working. But if you have a period of, say, 3 months or 28 days, ideally, you should have a short-term partnership agreement to govern that partnership that's in existence for that period. So the partnership agreement should set out the profit shares, any sessions. If you've got any fixed share partners, these terms also need to be included within the partnership agreement. You'll also need to give thought to the decision-making structure. So in a larger partnership, decision-making can be complicated. You may put in place governance structures to set out how decisions are made and how votes are taken. And you may want to delegate specific functions to specific partners. So, for example, a finance partner. If partners are joining, you also want to include terms relating to capital contributions or buy-ins to premises. Finally, I'd recommend reviewing your provisions in relation to outgoing partners. So, for example, when a retirement notice can be served and whether there'll be any restrictive covenants. And restrictive covenants are provisions that prevent partners from competing with a practice or poaching staff or patients. They can be difficult to enforce, so we recommend seeking legal advice if you're intending to include them or to enforce them. So, as mentioned previously, premises is usually the biggest asset or liability of a practice. Consideration needs to be given to whether the premises is suitable for the merged practice or the new partnership, or if you're going to be moving into a larger purpose-built premises. If the premises is freehold, you'll need to consider uh, when the new partners will be expected to buy in. If it's owned by retired partners, will it be leased back? And if there are non-property owning partners, who will be responsible for any repairs and maintenance? If the premises is leasehold, it's essential to review the lease, the length of the lease and obligations, or whether a new lease will be required, um, and also to look at any existing lease liabilities. So if there are any service charge liabilities that are lurking in the background. So finally, we would say, don't forget about the CQC. It's always one of those things that sort of is in the back of everyone's, but sometimes isn't dealt with early enough. So we always say, approach the CQC early. The applications that you make will depend on how the merger or takeover is structured, and processing times can vary. I think the last time I checked, it was about 10 weeks. Sorry, I think I got disconnected for a second there. Anyway, so I think the key points have been covered. I just wanted to say thank you for listening. I've set out a few details on why you may wish to use BMA law for your legal services, especially if you're merging or taking over a practice. We offer discounted rates for BMA members. We specialise in advising medical professionals, and as such, we have a deep understanding of GP mergers and takeovers. We also provide a variety of other specialist legal services which may be useful, such as property law advice, dispute resolution, and CQC and GMC advice. Those are just some of the services that we provide, so please do feel free to contact me or go on our website if you want to take a deeper look. So thank you very much. I hope you found this useful. I'll now take any questions. And my details are on this slide, so if you've got any questions that you'd like to talk to me about, please do drop me a line, send me an email, and I'll happily address those with you. But if I move over to the questions section, so I've got a question here saying, what does an indemnity mean? So I hope I did address that further up in some of my earlier slides. But an indemnity is essentially a promise to pay if a loss or liability occurs. So you can have a blanket indemnity that relates to the period prior to the takeover or merger. So any losses or liabilities that arise, so not just losses, liabilities, claims, proceedings, anything along those lines. If anything like that arises prior to the merger or takeover date, then you will be indemnified. So that means that the party giving that indemnity will pay for any breach of that indemnity on a pound for pound basis. So we'll essentially put you back in the position that you should have been if that loss or liability hadn't arisen. And then you can have specific indemnities, so indemnities for specific events that have occurred. So if you're aware that there's an employment claim and that costs may be flowing from that claim, or there may be damages or something to pay out, you can have an indemnity from the former partners, so from the former practice, saying that they will pay you on a pound for pound basis for any losses, liabilities, etc., that arise from that employment claim. So very useful to have, and that's one of the reasons why we always say make sure you do thorough due diligence at the beginning, because it helps unearth these problems and gives you the chance to then include indemnities within your business transfer agreement. The next question that I've got here is how important is due diligence? So with a GP transaction, we don't tend to see huge liabilities, losses, issues arising, but we would always say carry out some form of due diligence. So we do offer to do that, and whether we do it or not really depends on the takeover or the merger itself. So in more complex mergers, takeovers, in practices that are large, are of a high value, then we do tend to recommend carrying out some form of due diligence. Sometimes, if the transaction is relatively straightforward, then what we say is that you can probably go off and do some due diligence yourself, and that's legal due diligence. And what we can do is provide you with a questionnaire, and we usually do that as a gesture of goodwill. And that's so that you can go off and find out anything that you would like to know prior to entering into the merger or takeover. Um, it's also useful for us to see the responses to the due diligence, because it tells us what we need to be looking out for when drafting the agreements. So we would say, I would take it on a case by case basis. You can always ask us and say, what sort of due diligence should we be carrying out for our takeover or merger, and I'll happily give you my opinion. There is also financial due diligence, and I would always say speak to your accountant. And financial due diligence tends to be very important, because that relates to the losses, the costs, the liabilities that a practice may have, and that you may end up having to pay out for if you don't carry out that due diligence. Then I've got another question here. Is there any risks in particular that a smaller practice in a merger needs to be aware of? So in a merger with a smaller practice, there are several risks. You want to be looking at liabilities, losses of the other practice, but also your independence. And that's one of the things that I tend to get asked about a lot with smaller practices merging with bigger practices, is that the partners, especially if they intend to carry on in the merged practice, is that they lose an element of independence and control. And that's one thing that needs to be addressed and thought of, especially in your partnership agreement. And having that partnership agreement drawn up in advance, I would say, is very important, because at least at that point you have leverage to negotiate the terms. If more than one practice merges, what would be the additional steps? So if you've got, say, a merger of several practices, so 3-4 practices, it's relatively the same sort of process. The thing is you're just having to consider a lot more. So more partners, more practices, more losses, more liabilities, more there's more to look at, I would say. The structure of it doesn't really change, and there aren't really any additional steps, but there could be additional steps, say, in relation to the property. So if the properties are owned and occupied on different basis, then you would need to look at how the properties are held and what would need to be done in relation to each of those properties, and how you're intending to merge them all together. The same with staff. It's just a bigger process that takes probably a bit more time. So I would say giving yourself ample time, where there are more practices to consider, is really important. And the other important thing is making sure that you're all on the same page and you understand what you're all going into. And that's really important. And sometimes heads of terms can be useful to set out what the parties' intentions are. So as you get further down the line, say 12 months down the line, you're able to look back on those heads of terms and say, oh, well, this is what we agreed at the beginning, so that's what we should stick to. Because sometimes the message or the reason for merging gets lost along the way, and people get caught up in all the legal documentation and everything else that needs discussing. So I think, let me just see if there are any other questions. Right. Oh yeah, there's one more. So is there a standard trial period for the merger, or once in there's no out? I've got 1 minute to answer this question, so I might need to come back to you on it. But not necessarily. Once you merge, you merge. So once you've done your contract variations with the ICB, it can be very difficult to unwind, although not impossible. So we have dealt with demergers. There is also a provision called a long stop date within a BTA, which gives the parties the ability to unwind if certain conditions are not met. That can be a difficult process to go through. So I would say, if you're looking for something like that, reach out to us, and we will see what we can do and what we can include within your documentation. I think that's it in terms of questions, but please do reach out to me if I haven't managed to answer any of your questions today, or if you'd like a chat one-to-one. Thank you very much for attending.